Helping attorneys understand appraisers and appraisals. This is webinar number 2 in the series, Appraisal Options and Requirements for Legal Cases. We have several options that we're going to go over today, plus explain the standards that all appraisers must follow. The problems that we're running into with attorneys is they often, in fact clients in general, don't understand the difference between appraisals for lending and legal purposes. And there is a difference, usually in the level of information and quality. There's an issue relating to the different types of, shall we say, appraisals that can be used when there are legal issues, and I'll explain 3 of the options today. How the Supreme Court's Daubert ruling impacts the appraiser and your valuation process, and the applicability of appraisal standards and how they impact the credibility of the report. So let's start off with appraisals and some of the options regarding legal issues. Let's start with defining an appraisal. An appraisal is a report, oral or written, that describes the neighborhood, sales activity in the neighborhood, the subject's property rights, are they fee simple, a PUD, condominium, leased fee, and the like. The subject's real estate, the land, because that's the basis for everything. A lot of people think that they are house appraisers, and the reality is we are land or real estate appraisers, and then we try to figure out how the improvements add to it. When you deal with improvements, whether it's a house, a concrete building, commercial, apartments, docks, fences, and the like, we also have to describe the quality, condition, size, how these things are being used, and if there's any problems with the property. And the whole thing comes together as an estimate of value, and very important here, supported by facts. The output of this information is called an appraisal. It usually takes the form of a written statement, and it's based upon available data as of a specific date, although we can do appraisals in the past, today, or in the future. If there's a legal issue and you need to know what the value was 10 years ago, we've done that and can do it. Reports can take on numerous formats and provide varying levels of information, ranging from an oral report, a single piece of paper written on a napkin, if you will, up to 500 plus pages in what's called a narrative description. Typically, attorneys and appraisers have 3 primary appraisal options that I'll explain. What you're seeing on the screen right now we commonly call a form appraisal. It's a pre-made blank form. You fill in the boxes, if you will. It is a summary of the information that was used to determine the value. It's typically very minimal on details, kind of a summarization of what's out there, not all of the inside information. Very typical for bank financing and very common property types. Residential is what this is used for. These can be 20 to 30 pages and for the most part cost less than $1,500. I've seen them today in 2019 as cheap as about $350 up to $1,500, although we have charged $2,500 for several complex properties on waterfront. But typically you're going to be less than $1,500. The typical goal of these form appraisals is to establish the value as of a specific date, and we describe the condition of the property, or we can make it subject to the condition being different. We can make it subject to a house being built. What would its value be? Or we can make it subject to the house not have burned down last week. What would its theoretical value be on something like that? The common uses are for bank appraisals, lending. You can use them for estates, like establishing a value as a date of death. You can do it for estate and tax planning. That's what we do a lot of. It could be a sale between related parties. It could be the insurance value. We've done them where there have been fires and the houses are partially destroyed. And then we go out and determine, here's what we believe the value was prior to the fire, and then they use that for insurance settlements. Or maybe you're fighting your property taxes. You can use these form appraisals for any one of these, plus other options. Then option number 2 is called a narrative appraisal. It is much more information on this. There is no set form or format, although they try to describe the subject and the neighborhood and the subject site and the like, the same way that a form appraisal, kind of in the same format, but these are written on standard letter documents, if you will. These can be anywhere between 50 to 120 pages that I've seen for narrative, if not longer. And your costs, for the most part, start at $1,000 and go up from there. We see this typically for things other than residential property. The narrative appraisal is used for it's very common for commercial properties, industrial, agricultural, or extremely complex residential properties. For instance, if you're going to appraise Bill Gates' house or Paul Allen's 3-acre estate with multiple buildings here in the Seattle area, the form appraisal, you just can't get all the information on it, so you would fall back to a narrative appraisal. Typically, again, they include more information about the economy, the market, what's happening in an area. If you're in the Seattle area, you'd start saying Western Washington, King County, City of Seattle, and they give a lot of background as to what the economy is doing, home buyers are doing. It's usually, in fact, unfortunately, a lot of information can be it's just information that may help some people, but bores to tears many people who just, what's the value? What are we dealing with? These typically, again, contain far more opinion-based conclusions and are not as precise as an appraisal. I've seen often where they say the value is between $1 million and $1.2 million, something like that. Adjustments are very rare for some of these. It is, again, more opinion than you would see in a form appraisal. They can look very impressive, without a doubt. There's some very excellent ones, but they still rely upon a lot of subjective opinions, and often this leads to conflicts between appraisers, resulting in more court argument. This appraiser versus that appraiser have said this, and a lot of belly scratching and information. Good narrative appraisals exist, but finding competent appraisers who are capable of doing this more than just a lot of blah 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 information about the economy is far more difficult. If you need a narrative appraisal done in Washington, Oregon, some areas of California for ultra expensive properties, I can help and point the way for something like this. The third option is called a market study. And these market studies, again, are a little more focused on the issue or the problem you may have. These market studies are typically used to determine how a specific issue impacts the value of a property. For example, how does a detrimental condition or a problem such as a contamination, a landslide, a failed septic tank system, or you've got a real bad neighbor who's a biker dude from, oh my God, nowhere near be your neighborhood. How do these sorts of negative people impact a subject property or an entire neighborhood? These market studies can be 50 to 200 pages, and frankly, we only bill on an hourly basis for performing this. We have one right now in our office where the buyer moved in, and on the day they moved in, they discovered that the septic tank system had failed. In fact, had been failing for several years, which is why the seller sold it, who then exited the county and is trying to be hiding somewhere. And so the buyer is trying to figure out how much damage, what's the reduction in property value because the septic tank system has failed. And so in a case like that, we do these market studies to help them quantify that loss. Let me give you an example here. If you look at the photo, you can see that these houses are right next to the landslide. So the houses are still there. They're still usable if you really want to do that. So the question is how much has their values been impacted because they're next to a landslide or across the street from it? What sort of stigma is attached, the dollar amount of stigma that's there? And can we quantify it as opposed to my opinion is 10, 20, 50, 100,000. Can we prove or support that with evidence? That's what market studies can do. Here's another example. This is on an island called Vashon Island outside of Seattle, and this is the building that was permitted and is shown in the county records as receiving a building permit to build this on the shore. Here's what it looks like today, several years back. The gentleman, they had bought the property and then sat there over years, just kept building on and creating the house that you see on the right. There are no building permits for this house to exist on the right. And the septic tank system, well, it doesn't work all that well, so it just kind of bubbles up out in the sound that's there. So we were asked to come in and determine what is the hypothetical value of this house if it had a building permit, which is roughly $1 million, and then what is its value without proper building permits being issued. And our market studies help establish that loss of value between a legally permitted and, in this case, a non-permitted with a failed septic tank system. Here was another one, and this is in a subdivision of newer homes, and the arrows point to some little areas. These were called cemeteries. They were Civil War cemeteries. The builder came in and subdivided the land into these lots, built houses on them, and just kind of forgot to mention to the buyers that there were cemeteries underneath the houses, or in the backyard, as the one on lot 81 or 61 that was up there. And so all of a sudden, they need to know what is their loss of value because they have a cemetery in theirs. And a market value helps establish that loss. We can establish a single point of value using an appraisal, and then a market study to indicate the loss of value due to being built over a Halloween cemetery. Now, another thing you should do is no matter what, whether it's a form appraisal, narrative, or a market study, you need to read it. These things are supposed to be written in such a way that the client can understand them and their conclusions. If you get a report from an appraiser and there are terms and conclusions and a lot of jargon that's in there and you don't understand it, that is not your failure. That is the appraiser who has failed you. These things have to be written in such a way that not only do you, the attorney, need to understand them, the client, the property owner, but also a judge and a jury that's out there if they get to look at these. So if you read through an appraisal that you have ordered or is produced from the other side of this argument, read it through, and if you don't understand it, get it fixed before submitting it as evidence. And if it's still difficult for you to understand, maybe you selected the wrong appraiser for your side of this argument. So here is a quick example, and I see this every day, particularly when we're reviewing appraisals for legal purposes. So within this appraisal, the appraiser said the appraiser may or may not have provided prior services on the subject property within the past 3 years unless otherwise stated. What? It's boilerplate. Maybe I did, maybe I didn't, maybe I did, so read somewhere else. This is a terrible way to have done something like this. But I often see this in form appraisals because they were written for banks and a lot of boilerplate. And you shouldn't have this sort of boilerplate in your legal appraisal. So, which path do you as an attorney want to take? Talk to the appraiser. Describe your problem and question them on which option they recommend. Maybe at the end of the day they go, this is too complex for me, I don't want to have anything to do with it, call Hager or somebody else. Okay. But you need to know, do you want to go on a form appraisal, a narrative appraisal, or some sort of market study or combination? Consider which type of report will best convey information to the judge and jury. Which one will help them understand this problem and have clarity. And don't try to think you can hide it in smoke, in mirrors, because doing so just creates more problems than it's worth. I would recommend that you ask for samples that you can review and consider prior to deciding which path you want to take down this appraisal. Now, usually, here's a path that we go. Usually we provide an appraisal establishing the value, a hypothetical value for the property, assuming that there's no problems, like I did with that one without a building permit. We valued it assuming it had a building permit. What's the maximum value it'd be worth, which was around $1 million. Then we do a market study indicating how this lack of building permit or operating septic tank system impacts the value, and we usually come up with a percentage. So in that particular case, that $1 million property lost approximately 50% of its value due to the lack of building permits. And our market studies, we're able to prove that very conclusively based upon, believe it or not, we found a lot of other houses that had been built without building permits, and we looked to see how their sales prices had compared to those with legal building permits. That's what a market study can do. So, in addition, there's appraisal standards. In other words, there's some rules that must be followed. For the most part, state and federal laws require appraisers and appraisals to comply with certain written standards. These standards are not law. However, various laws, federal and state, require following the standards. Doing it this way allowed the standards to be tweaked, if you will, every couple of years without having to pass it through the Senate and the House and everybody else to sign it. So they refer to appraisals having to follow the standards. The standards cover appraisals for real estate, mass appraisals for tax purposes, and including valuing personal property. And the standards are updated every 2 years. Like, that's not good enough. The purpose of the Uniform Standards of Professional Appraisal Practice, commonly called USPAP, is to promote and maintain a high level of public trust in the appraisal practice by establishing requirements for appraisers. By the way, that comes right from the front page, the first page of USPAP. It is essential that appraisers develop and communicate their analysis, opinions, and conclusions in a manner that is meaningful and not misleading. That simple statement right there, unfortunately, there are many appraisals that just don't communicate that, and it creates a problem. The standards cover all sorts of things: record keeping, ethics rules, confidentiality, who can I talk to, what's called competency rule, who can do what, when, where, how. For instance, I'm a residential appraiser, so I would not consider myself competent to be doing appraisals for massive high-rise buildings or 100 to 300 unit apartment complexes or Apple storage places. I'm not competent in that property type or in a certain area. It also covers the scope of work, which is supposed to be an agreement, an outline of what will be done, when, and how, and what sort of information will be conveyed back to the client. The steps to be taken in analyzing a problem or the property require the use of acceptable methods and procedures, which I'll go into in a second, and how that information must be disclosed in a report. Failure to follow the standards renders an appraisal non-credible. If the appraiser does not follow the required processes, then the appraisal is rendered worthless, even if the value is correct. It's a dart throw if they hit the right value somehow. If they did not follow the right processes, you cannot trust their final conclusions. So if we are doing review work in a legal case, one of the first things we do is we review the opposition's appraisal or market study for compliance with the standards. And if they don't comply with those, then you have your, shall we say, first angle of attack on how to maybe have the other appraisal declared non-compliant and cannot be used in your legal argument. An appraiser must conform and perform assignments with impartiality, objectivity, and independence without accommodation of a personal interest. This is called the conduct rule within USPAP. So what this means is an appraiser must not perform an assignment with bias, must not advocate for the cause or interest of a party or a particular issue, must not accept an assignment that includes the reporting of a predetermined opinion, conclusion, or value, The problem that I run into often is many appraisers are biased. Well, heck, I guess we're all biased to some degree, but many of them are biased, and their appraisal reports clearly indicate this. It's like they're going out of their way trying to be helpful to whoever their client is, or their cause, or their point of view. And we are not supposed to be advocates for the client. We're supposed to be a disinterested, independent third party saying, here's what the value is, or the impact on value for not having a building permit or something. And this is probably the biggest failure that I see. I was doing some appraisal work in Montana, and the appraiser on the other side clearly was biased in that because he happened to own a very similar property type down the lake shore and was not properly representing his involvement. And again, this is where we find a lot of problems with appraisers and often are able to get them removed as expert witnesses. An appraisal or market study cannot simply be based upon the appraiser's opinion. You can't, lean back in the chair, scratch their belly, and go, here's the value or here's the impact. It's not supposed to be. The report must follow recognized processes and use common techniques and methods in reaching their conclusions. Anything less than following the right steps, if you will, is going to look like a biased conclusion, non-credible. This is extremely important for appraisers to quantify adjustments and their conclusions. They should try to avoid using subjective opinions or conclusions. The reason is if you get two appraisers that are very subjective with opposite conclusions, you're just going to have a long-term fight on your hands. And that's not going to help anyone, except for, I guess, the attorneys and their income. So appraisers need to use verifiable facts. There is a process to follow. So to kind of give you a couple of information slides on this. This is called the Daubert ruling. And from the Daubert ruling, it flat out said, this is from the Supreme Court, by the way, the appraiser's opinion is not persuasive to the court. That's the last thing you want to have happen to your appraisal or your market study, is to get into any court system and have them come back and say, yeah, this is nice, but it's not persuasive, and have it thrown out. At that point in time, your legal argument probably goes down the drain. The Supreme Court went on and said, we conclude that the appraisal report is not admissible because the author did not apply reliable principles and methodologies. So let's look at the standard 1 and that relationship to it. This is just one of 10 standards within our standards that are there. Standard 1-1. A. An appraiser must be aware of, understand, and correctly employ those recognized methods and techniques that are necessary to produce a credible appraisal report. So what this means is, no matter how the appraiser comes to their value conclusion, through a cost, income, sales comparison, how they determine adjustments, and all sorts of things that are used in an appraisal, the methodologies and the processes they use, they have to be based upon a recognized, standardized, and or repeatable process. So one way to look at that is does the method the appraiser used have a name for it? Oh, this is a matched paired analysis. Or could a competent appraiser understand an explanation if they didn't have the name? If someone doesn't understand the explanation or the name, could they read about this in an article or book that's somewhere that explains this? And more importantly, can a review appraiser, somebody working for the state or for the other side looking at the file, can they recreate the same result? So what it means is they must follow a standardized, repeatable process to come to their conclusions. You cannot just guess. So the point here is an appraisal or market study must comply with the standards, and not just a few of them. When working with an appraiser on a legal case, the engagement letter should include a requirement that the appraiser and the appraisal or study comply with the standards. There needs to be an understanding of that. I'm dealing with a case right now, and there was no agreement by the other side to produce an appraisal that complied with the standards. And so now there's a large argument about whether it does or it doesn't. Who cares what the value is? So you need to get this done up front. It will simplify your case and prosecuting of your case much, much easier when you get to trial. The last thing any attorney needs is an appraisal being rejected because it fails to follow the standards, methods, or processes, or it appears biased because somebody was rah rah sis boom bah for a particular opinion. That's not a very good thing. You should have all appraisals reviewed for compliance with the standards. I would say if you really want to have this perfect case, if you will, you should have your own appraisal. Whoever's working for you on your behalf, you should have his or her appraisal reviewed for compliance to make sure, have an outside audit, if you will. You should also, without a doubt, have the oppositions, whatever their appraisal report is, reviewed for compliance. That is the first thing that we recommend any legal cases, if we're involved with, is let's review the opposition's reports for compliance with USPAP, and then we can decide how to proceed. I do understand it's a balancing act between costs and a defendable appraisal, because we charge on an hourly basis for that. If the appraisal on the other side is compliant, our appraisal review is usually done in 4 to 5 hours. If the report on the other side is terrible and is out of compliance, it may take days for us to write up a review. We did one on a very ultra expensive property, and the appraiser did a terrible job of doing this, and our appraisal review was 45 pages long because that's how bad the appraisal was. Who cares what the value conclusion was? They didn't follow the right processes, use the right methodologies, and there was a lot of subjective opinion with clear indications of bias in there. So compliance with the standards is your first line of attack on an opposing appraisal or market study. And again, if they can't follow the process, how can you even trust their value conclusions or where they're trying to convey information to you? For the most part, you can't. So that's all we're going to talk about appraisals today and the standards, just giving you a once over. There's no reason to go into this in much more detail. If you need that, you'll follow up with your appraiser. In future webinars, I'll try to explain the scope of work and what it means to the appraisal process. And what that means is how hard the appraiser will be working on your behalf, what sort of information will be conveyed. I'll also explain one of the most common conflicts between the value real estate agents come up with versus the appraiser's value conclusion. Appraisers must follow a federal definition of market value, which I'll explain in following webinars. And frankly, how to spot problems with only about a 15-minute review on your part. So if you're caught between a rock and a hard place at a deposition, sometimes I can point out a quick way to look at the appraisal and point out some problems. My name is Richard Hager. You can see my background here. I'm a real estate broker, real estate appraiser, SRA with the Appraisal Institute. I also do fraud profiling for law enforcement, and I try to help banks understand this process. I'm a member of the International Association of Financial Crimes Investigators, and I'm the chairman of the Mortgage Fraud Task Force. I have co-authored the Washington Mortgage Brokerage Practices Act. That was later converted in to become what's called the Federal SAFE Act. You can look that one up. I also have helped in creating other licensing laws for AMCs, foreclosure distressed, and the like. So if you have other questions or need other information, there's the websites at the top. American Appraisals will take you right to me, or our school on this called the Hager Institute. If you have anything that you need, you can email me directly at RH at American Appraisals. So if you need a skilled expert witness, I guess, anywhere on the West Coast, maybe even Florida, I can help point the direction for some of those. So it's if you need more information, you can reach out and contact us here.